So turning first to the question of a minor. Can a minor enter into a valid contract? And we're going to do this by looking at the 4 legal systems that we are studying during this course. Turning first to English law. And under English law, we see that in general, a contract with a minor is not void. So it's not as if there is no contract that has come about. However, the contract is unenforceable as against the minor. The minor, however, can allow the contract to go ahead and it can be enforced against the other party. So here the law in general says it is possible to create a contract with a minor. However, it is not possible to enforce the contract against the minor. However, the other party does remain bound by the contract. There are more specific provisions dealing with the capacity of the minor that we can find in the Sale of Goods Act. And in particular, we find in the Sale of Goods Act, Section 3, which tells us that there are certain types of contracts that can be enforced against the minor. And in particular, we are dealing here with contracts where necessaries are sold and delivered to a minor. So in the case of necessaries, such a contract can be, in the case of a contract with necessaries, that is a valid contract that a minor can enter into. He must, however, be contracting on the basis of a reasonable price. So at the point in time that the price that the minor is paying for the goods that are being sold and delivered is out of bounds, is beyond what would be reasonable, such a contract would not be valid in accordance with Section 3 of the Sale of Goods Act, or at least it could not be enforced against the minor in accordance with Section 3 of the Sale of Goods Act. A relevant question that we then have to ask is, well, what are necessaries? How do we understand the concept of necessaries? What types of sale of goods contracts are we dealing with then? We don't have to look far. We find in subsection 3 of Section 3 of the Sale of Goods Act, 1979, that necessaries means goods suitable to the condition in life of the minor and to his actual requirements at the time of the sale and delivery. So we have to look at the suitability of the goods that are being sold to the condition in life of the minor. Is this something that a minor would generally be expected to be able to buy? And does this particular minor does it actually meet his, or does it meet his actual requirements? Does he need these particular goods? And here we can get into conversations about, well, what in a certain time within society is something that minors can be expected to buy. And this might change over time. For example, whereas 10 years ago it may have been quite unheard of and unnecessary for a minor to have his or her own iPad or telephone, mobile phone. Society might change to such an extent that this is quite an ordinary type of transaction that a minor would enter into these days, and therefore could be qualified as a necessary. The question is, does a minor subsequently need 10 iPhones? That doesn't meet the actual requirements of a child at the time. So then we would say it no longer qualifies as being a necessary. Beyond contracts for the sale of goods, we also see that there are some specific cases that have been dealing with the question of apprenticeships, training, or employment. So we see that minors, those under the age of 18, may enter into part-time jobs after school to earn some extra money, may start an apprenticeship, may be involved in training contracts, And this is also an area in which the law then says, well, we have to promote the personal autonomy of the minor in such a case to be able to develop themselves. To protect the minor from exploitation in such a situation, the law does put some limitations on it, in the sense that the contract for apprenticeship or training or employment is enforceable, provided that it's for the benefit of the minor. At the point in time that it's not beneficial for the minor, that they are held to an employment or an apprenticeship or a training contract, at that point in time, the law would step in to say, well, this goes beyond the legal capacity of the child, and therefore it would be unenforceable against them. So what about French law? Does a minor have the legal capacity to enter into a contract? If we look at Article 1146, we see that a minor does not have the legal capacity to enter into a contract. A minor is represented by their legal representative or parent in any legal transaction or legal act. And we see this further elaborated on in Article 388(1) of the French Civil Code. That being said, there are certain situations in which a minor could enter into a valid contract. And this is to be found in Article 1148 of the French Civil Code. And there we see that a minor can enter into common transactions provided that they are made under normal circumstances. So it becomes important to see whether or not the minor has entered into a contract that would commonly be entered into by minors of that age and in that setting, and to look at the circumstances under which that contract was entered into, in particular looking at the terms on which the contract has been made. Now, in such a case where the minor enters into what we refer to as ordinary or common transactions, the contract would be concluded, and the minor would therefore have the legal capacity to do that. However, even such a day-to-day transaction or a common transaction can be annulled if there is some economic disadvantage that constitutes lésion for the minor having entered into that contract. So this can be found in Article 1149. So we see that there is a general rule that the minor cannot enter into a contract, does not have the legal capacity. There is an exception to that rule in the case of common transactions under normal circumstances, but even in the case of common transactions under normal circumstances for a minor, they can be annulled in case of an economic disadvantage. So if a minor enters into a contract where it doesn't have the legal capacity, so we're talking about a contract that doesn't fall within the scope of these common transactions or these day-to-day transactions that minors generally enter into, then the contract does not come about. However, the law does tell us that a minor cannot invalidate, or his legal representative cannot invalidate the contract if the contract was useful for the minor and he does not suffer an economic disadvantage in terms of a lésion. And this we find in Article 1151 of the French Civil Code. Similarly, if the minor has entered into a contract for which it doesn't have legal capacity, so in other words, it's not a common transaction, it's not a day-to-day transaction that would fall under Article 1148, the contract itself cannot be invalidated for the lack of capacity if the minor has profited from that contract. So that's also in Article 1151. So we see the general rule that the minor lacks capacity to enter into a contract. Nevertheless, if the minor does enter into a contract and subsequently tries to invalidate that contract, that would not be possible if A, it was a contract that was useful to him and he doesn't suffer an economic disadvantage, or B, if the minor has actually profited from the contract. Now, a third scenario in which a contract made by a minor lacking capacity could nevertheless still be valid is where the legal representative provides consent for that transaction or that contract to be concluded. German law also has a number of provisions dealing with the legal capacity of a minor. The general rule that we find in German law is that a minor requires the consent of the parent or the legal guardian in order to be able to enter into a contract. So only with consent of the parents can the minor enter into a contract. There are some more specific provisions dealing with different scenarios with respect to the capacity of minors. And here what German law does is it makes a distinction based on age, specifically, expressly within the Civil Code. And therefore we see that in paragraph 104 of the German Civil Code that a minor below 7 is wholly incapable of entering into a contract. So there is no legal capacity whatsoever for a minor to enter into a contract under the age of 7. However, for minors between the age of 7 and 18, there is some capacity to enter into contracts. And this is laid down further in paragraphs 106 to 113. So in paragraph 107 of the German Civil Code, we find that a minor can enter into a contract where the minor only receives a legal benefit, and such a contract would be valid even without the consent of the parents. So provided that there is no burden on the side of the minor and that the minor only receives a benefit from the contract that is entered into, that would be a valid transaction that a minor between 7 and 18 could enter into. We also see in paragraph 108 the possibility for the parent to ratify a contract that has been entered into by a minor without the parent's consent. And when we're talking about ratification, we're talking about giving consent or approval after the fact. So if a minor has entered into a contract without the consent of the parent, such a contract would in essence be invalid because it falls outside the legal capacity of the minor. However, if subsequently the parent ratifies that contract, then providing its later consent, then we would have a valid transaction. We find an interesting provision in paragraph 110 in the German Civil Code, which is colloquially referred to as the pocket money provision. So under paragraph 110 of the Civil Code, a minor can enter into a contract using money that has been given to it by his or her parents with the specific purposes of being able to use. So if you're given pocket money with the idea that you can actually spend and use that pocket money to purchase certain goods, then the minor can enter into contracts using that pocket money can enter into contracts using that pocket money irrespective of the consent of the parents with respect to that specific transaction. And finally, we also see that there is a specific provision dealing with employment contracts that are entered into by minors under paragraph 113. And finally, turning to Dutch law. And here we see that the consent of the parent also plays an important role. The key provision that we are looking at is Article 234 of Book 1. And within this article, you see that there are three paragraphs. The first two deal with the scenarios in which the minor has entered into a contract that requires the actual consent of the parent or the legal representative of the child. The final provision, paragraph 3 of Article 234 of Book 1, gives us a presumption of consent. So we need to read these first two provisions together, and then we see that there is an alternative ground on which to base the capacity of the child to enter into contract. In the absence of the actual consent of the parent, the law makes a presumption. So turning then to paragraph 1 of Article 234 of Book 1. And it reads, a minor is, as far as he acts with the approval of his legal representative, capable of performing legal acts unless statute provides otherwise. So provided the minor has the consent of the parents, the approval of the parent or the legal representative, he or she can enter into a valid contract. Now, the approval that we are talking about, the specific actual, or I should say the actual approval that we're looking at with respect to the minor entering into a legal act, can be given for a specific legal act or for a specific purpose. And this we find in paragraph 2 of Article 234 of Book 1. So these first two paragraphs within Article 234 of Book 1 very much looks at providing the minor with the ability to enter into contracts, provided that there has been consent given by the legal representative, by the parent. Turning then to paragraph 3 of Article 234 of Book 1, we see that the legislator recognizes that it is not always convenient to have the parent or the legal representative be present to give actual consent for the conclusion of the contract. And the legislator recognizes that there are certain situations in life in which a child would normally be able to enter into a contract. And thus we see in paragraph 3 of Article 234 of Book 1 that there is the possibility to establish that the consent was can be presumed to have been given by the parent. And there it says that approval is deemed to have been given to the minor where it concerns a legal act of which it is generally accepted practice that minors of his age perform it independently. And the key thing here is going to be to establish, well, what is generally accepted practice for a child to be able to, or what kind of contracts are generally accepted practice that a child of a particular age is able to enter into independently. And that will depend on the circumstances. It will depend on the age of the child. It would also depend on the time within society. So what can we conclude with respect to the capacity of a minor to enter into a contract? Well, in general, based on our comparative survey, we could say that if the contract is to the benefit of the minor, or if it is generally accepted that a minor of this age can enter into this particular type of contract, then the contract is binding upon the minor. However, what we do see is that there are differences with respect to the legal technique that is used and the way in which legal systems approach this question. And we also see that there are differences with respect to how to establish whether or not the contract is beneficial to the minor.